Good afternoon, everybody. Aaron Keller here on the Law and Crime Network. We're continuing to follow the Tex McIver case out of Atlanta, Georgia, the case of an attorney who's facing murder charges related to the death of his wife. He says it was an accident. He says he was riding in the back seat of a vehicle when a gun he was holding went off. Why did he have the gun out? Well, he says it was because there were some people in the street and he was afraid for his safety, possibly at one point tied into the Black Lives Matter movement. He was afraid of people congregating and attacking him in a vehicle. Now, the state says this excuse is just an excuse to try to cover up for a crime, but the jury ultimately has to decide. We've been listening to testimony this afternoon from a woman who was a legal assistant at the corporation that was owned by the victim, Diane McIver. A lot of testimony this afternoon on specific points of the knowledge of people close to the McIvers. One big area of argument this morning had to do with the victim's files and exactly what was going on with files. Why did the defendant have some of his associates apparently take the files away when many of her close associates said that those files were her private files? Nobody went in there. Was it just part of an estate cleanup? Was it an attempt to wash information that could have been relevant to this prosecution? Certainly both sides have their argument, but it's another little twisted fact that we can get into here. So as we continue to analyze this case, let's bring in Gary Gerstenfeld. He's an attorney who's joining us this afternoon here on Law and Crime. Gary, good afternoon.
Good afternoon, Aaron. It's good to see you.
So what do you make of this? We've got all of these business associates of the victim who have been up on the witness stand talking about their knowledge of the way that she lived her life, the way that she ran her business, the way that she kept records, and ultimately how they found out about the death. This is shaping up to be a very lengthy trial, and many of these witnesses are basically telling everything that they know, their entire life story as it relates to not only the victim but the defendant. What do you make of where people are going in this?
You know, I'm not really quite sure, to be honest with you, because it's a 10-year marriage. There's really no evidence that there were real serious problems in the marriage. It seems that they're pretty happy, and they're not really focusing on what happened in the car. It seems to me that if you're prosecuting in a murder case, what happened in the car is really what you need to focus on. The problem that the state has, or the government's going to have in this case ultimately, is that they're weak on motive. And the defense is it was an accident. And it's going to be very difficult, I think, ultimately to really put a lot of holes in the defense argument that it's an accident. So trying to pick up on these other issues, trying to show something else, is really about all that the government has.
You know, I said yesterday that this may be an incident in search of a motive, and one of our guests who joins us regularly here picked up on that and tweeted it out before I got a chance to, but I'm going to take credit that I was quoted for coining the phrase. It sounds like you would agree that this may be an incident in search of a motive.
You know, it's one of those things where, you know, he's 70 years old, he's in the backseat of the car, they're in an area of town that gets him going, he gets angry, he gets upset about whatever it is. You sort of see this grandpa kind of guy, he's having a little diatribe about this, that, and the other. Probably, I think they're going to have to acknowledge some sort of a racist rant that he's having. He's got a gun in his hand. You know, it's one of those things where I think truly, again, angry people, 70 years old, sitting in the backseat of the car with a loaded handgun, and gee, something bad happens, you know? I'm not sure that's a murder case, but it's certainly a good argument for gun control.
Yeah, you know, another thing that was brought up yesterday was the defendant's relationship with his law firm, and we just took hours and hours and hours to go through his salary history, his various job titles. He was an equity partner. He was another sort of partner, you know, like entitled to profits. And then he was dialing back. And the prosecution is trying to use that to say, oh, look, his salary was cut more than 50% in the course of this. What I looked at was just, look, this guy's 70 years old. He was making bank for years. He was probably dialing back his responsibilities. What is nefarious about that? You can't necessarily read anything nefarious into a guy saying, hey, you know what? I'm going to dial back from dealing with all of the firm inner workings. I don't need the money anymore. Yeah, they're trying to say he owed money to his wife, but They kept separate finances. It was a later in life marriage for both of them. They were both independently successful. That's not necessarily nefarious. It's different than the way many other Americans live their lives, but again, it's not necessarily nefarious.
Aaron, it's an excellent point. You know, both of them had their separate lives. They both, you know, they met in this condo. It's an expensive condominium. They both happened to be neighbors, and they had similar interests, apparently, and they fell in love. There's a little bit of an age difference between the two. One of the issues that's kind of interesting is that, you know, that this idea of the missing will, and there's some sort of a financial issue and motive going on. No.
Yeah, let's throw back to court now. It looks like the jury questions are being asked of the witness.
Okay.
That courting U.S. Enterprises to open, so you didn't have to be buzzed in.
Yes.
You described the observing professional interactions between Mr. McIver and Mrs. McIver because he was an attorney for Fisher and Phillips working on some matter. Do you recall any instances when the two were interacting professionally, when there'd be a little break in the action and they would somehow interact in a way that showed they were affectionate to each other? In connection with what I just said, can you share with the jury your understanding of this airport case and what the nature of the dispute was that Mr. McIver's firm was helping U.S. Enterprises or courting Enterprises with?
Okay. There was a lawsuit that was filed pertaining to the airport bid at the Atlanta Hartsfield Airport. It was against Clear Channel and the city of Atlanta, and Fisher and Phillips was our attorneys.
When you say airport bid, who was bidding for what at the airport?
We, Corey Airport Services, which is one of the companies that's under the umbrella of U.S. Enterprises, had actually bid on the airport, and there were some discrepancies in there that caused a lawsuit to be filed.
When you say bid on the airport, not to own the airport or build the new runway, to do what at the airport?
Right. When I speak of the bid, what we did was when you walk into the airport, you see all the flashing billboards and everything with the advertisement on it, car dealerships, colleges, and all of that. We were the company that would place all of those in there. So if you had gone to Louisville or Cincinnati Airport, Palm Springs Airport, those were some of our airports that had all these things in there, and we were actually bidding for Hartsfield Atlanta Airport.
And some dispute arose over the way the bidding decision was made?
Correct.
Okay. When you were asked what your last words were to Ms. McIver, you shared with the jury what they were. Was that a typical way you ended a conversation with Ms. McIver?
Yes. We that was a part of our little dialogue. If one was upset with the other, she would say something else in a different context with me, and my remark would be, well, I love you too.
Mr. Rucker, any follow-up with Ms. Williams based on that?
No, sir.
No, Your Honor.
Ms. Clark-Palmer says no either. You are free to go. Thank you so much.
Thank you.
So before we bring in the next witness, I don't typically share with you all what's written on these questions, not because they're confidential, but some of them may not get asked. But I appreciate that one of them ended with effectively, you better ask this so that no one Googles it tonight. That's the point of the questions. Thank you for posing your questions. Reminder that if you submit a question and it's not asked, it's not evidence that it wasn't asked, your question is not evidence. It just means that, as you've now experienced many times, lawyers can ask questions that prompt other lawyers to stand up and object. And if I sustain it, it means there was a problem with that question. All in due time. We can take an afternoon break now. We can get partway through whoever the next witness is and then take a break, agreeing that it might be, say, 3:45-ish. You all tell me, you want to go for another half hour? Then pointing your finger at the wall means break? Okay, we're going to take a break. I need you all to be on point. We will get back together a little before 3:30 to follow up with the next witness, unless you all need more time. Thank you so much.
All rise for the jurors.
There you have it. The judge has called a break of about 15 minutes, of course, unless the jury wants to go longer, in the Tex McIver case out of Atlanta, Georgia. We remain on the line with Gary Gerstenfeld. Gary, we were talking about just where the prosecution is trying to go here. They started the case yesterday. We have been listening to all of this testimony from the business associates of the victim. I guess normally this would be a place in a trial where we would be hearing from family members, but in this case, it is the family member who's in the defendant's chair. So maybe this is a way to try to humanize things.
Her and how she was dressed, and I heard argument from both sides and sustained the objection, and that meant Mr. Rucker wasn't able to go a little further down that road. Is there anything more you want to get on the record? Sustain the objection, but is there more you want to make?
Your Honor, at the bench, I think I asked you to instruct the jury to disregard it and withdrew that request.
Correct.
But I would ask to strike that testimony from the record about how Ms. Carter was dressed and whether Mr. McIver was there.
Okay. Anything else you want to add to my recitation of what we discussed at the bench? Mr. Rucker, anything else?
No, sir.
Okay. I'm going to leave things as they are. Anything from the state before we break?
No. You said we're back at what time, Judge?
A little before 3:30. Who's our next witness?
Samantha Watson.
Okay.
She's
ready for that?
Yes.
Okay. I'll learn who she is.
Sorry about that, folks. We went back on the record for a little while outside the presence of the jury in the Tex McIver case. But, Gary, I think you're still on the line with us here, and we were saying that this trial has started out in a less than usual way. Normally, of course, at this point, we're hearing from family members and things of that nature. We did hear from some friends yesterday, but look, the bottom line is that this is an accusation that a husband murdered a wife. And the motive, as alleged by the state, is that it had to do with her vast financial resources, or at least that's what's alleged. So is it possible that the state's really trying to get the jury into this case by understanding the victim and the way that she functioned as a business executive?
Well, you know, who knows where they're going with that, because she doesn't own the business. Now, she makes a decent income, don't get me wrong, but at the end of the day, she's a W-2 employee. The money stops when she stops working. She doesn't own a piece of the business. So I'm not sure how that matters. His finances, or the fact that he's not making perhaps as much as he was making in the past, doesn't matter. He still has a 64-acre ranch. He still has the fancy condo. $60,000 engagement ring is what he gave her. I don't think he's hurting financially. He's 70 years old. You know, I don't think money is really the issue in this case. And even if it were, if the motive is to kill his wife to somehow get her money or to solve some financial problem, there's a 64-acre ranch. I mean, there's plenty of places to have an accident that certainly make a lot less suspicion than shooting your wife in the back of the moving automobile with her friend, the hairdresser, who's driving at the same time. It's a strange way to have an accident and not be the number one suspect, since you're admitting that you're the one that actually was holding the gun when she died. Is that, you know, it's bizarre.
It's certainly a different case, you know, but you've got to wonder, is the jury going to look at this and just say, hey, look, you know, we don't buy this guy's excuse that it was an accident. He shouldn't have had the gun out that way. He shouldn't have been holding on to it while he was dozing. And, you know, I think one relevant piece of this is that the gun was allegedly still somehow in this bag that he kept it in. So, you know, exactly how was he holding the gun, and will the defendant take the stand to explain any of this? Because if he doesn't, who else is going to? Of course, unless he told an investigator and it comes in that way. But there's a lot of what-ifs here, you know, a lot of what-ifs about whether or not it was thumb-cocked or whether it wasn't. If it was, it's a lot easier for that trigger to be pulled, and we heard that in the opening statements. So a lot to unravel here, but ultimately does the defendant have to get up there and try to explain all of this?
You know, the funny thing about this part of the story is that I believe the way he got the gun was, now he's in the backseat of the car, he's sleeping. Danny Joe Carter, the hairdresser friend, is driving. She gets off the main road of the highway, and then they're in a bad part of town. He then asks for the gun. It was apparently in the glove box or in the center console, and it's the wife who hands him the gun in the bag. Now, why the gun's in the bag, I don't know, but she gives her husband the gun. So, bad judgment, yeah, giving the gun to him, so, bad idea, but she's the one that handed him the gun, and I don't think that's an issue. I don't think that's an issue for the state. I think they're going to have to acknowledge that. So, yeah, it's kind of retarded. It's kind of silly that he had the gun, but his wife is the one that gave it to him.
A lot of discrepancies. We're going to listen to some clips from the testimony of Elaine Williams. She was the legal assistant there at U.S. Enterprises, the company where the victim was the CEO. Here she's talking about the victim's demeanor not long before she died.
Do you know whether or not those file cabinets were kept locked or not?
Yes, they were.
Were you present in the office in the days after her death when attempts were made to get into those file cabinets?
I was in the office, but I was not a party to it.
Okay. You were not a party to it?
No.
Okay. How did you find out that something had happened to Diane McIver?
I received a phone call as I was leaving home.
On what day?
Monday, September 27th.
Okay. Is it possible that Monday could have been the 26th?
I'm sorry. Yes.
Okay. And can you tell the jurors, did you have any conversations with Diane McIver in the Sunday or Saturday right before her death?
That Friday was the last time I spoke to her.
Okay. And do you recall where you were when you spoke to her?
Yes, I was in my office, and she was walking by.
Okay. At the time she was walking by, did you know where she was going?
Yes, she was preparing to go to the ranch, from my understanding.
And was she going to the ranch alone?
No, she was not.
And can you tell the jurors who was she going to the ranch with?
Her husband, Tex McIver, and Danny Joe Carter.
And over the years, you had come to know Danny Joe?
Yes, somewhat.
Somewhat?
Yes.
Okay. And can you tell the jurors on the Friday, which would have been what date? I just don't want to put it in your mouth. If Monday was the 26th.
The 24th. 23rd, I'm sorry.
Okay.
You didn't know this was going to be a quiz.
I did.
It's okay.
It's Friday, September the 23rd. That would have been the last day that you would have seen Diane McIver alive.
Yes.
Would that have also been the last day that you would have talked to her
Yes.
and that she would have talked to you?
Yes.
Do you recall about what time it was when you saw her walk by?
I would say probably about 4-ish in the afternoon, but I had seen her around 2:20 that afternoon. I
Okay.
had some words with her.
Okay. And so, do you know who Gail Meadows is?
Yes, I do.
Who was Gail?
She was the receptionist.
Okay. And did you have a conversation with Gail about Diane McIver's husband coming to the office on the day before? Thursday.
Objection. Calls for hearsay. And I think it was a leading question.
I'm all right with the leading or not, but how?
I'm not asking her what. I'm just asking her if she had a conversation.
Questions
Yeah.
suggested the content of the conversation.
Right. So I'll
Okay. Okay. I'll try to rephrase it. But I understand the court is sustaining the objection.
Correct.
Okay, I didn't mean to cut you off.
No.
You talked to Gail Meadows.
Yes, I did.
Did you talk to her on Thursday or Friday?
Thursday.
And after you talked to Gail Meadows on Thursday, did you see Diane McIver on Friday afternoon about 2 o'clock?
Yes, I did.
And when you saw Diane McIver on Friday afternoon at 2 o'clock, where did you see her?
She was seated in her office.
And how is it that you came to see her sitting in her office?
I was coming up the hallway past her office, and she was seated there, and I actually walked past her and realized that something was not right, and I backed up and I had some words with her.
Okay. And can you tell the jurors when you, did you look at Diane McIver?
Yes, I did.
With your own two eyes?
Yes.
And when you looked at Diane McIver, can you explain to the jurors what you saw?
Your Honor, may I ask sort of a pre-objection, just without offering an opinion about what was
Right. I'm now familiar with the area we've reached, and it was subject to some pretrial motions and some assurances from the state. So I trust you will navigate these
Yes, sir.
waters carefully.
And so, before you give an answer, please don't give any opinion about what you saw. I just want you to describe for us, in as much detail as you can, what you saw. You understand the distinction?
Yes.
Okay. Okay.
She was distraught. Is what I saw. And I asked her.
Okay. What did you ask her? What did you ask her?
I asked her what was wrong.
Okay. And how long did that exchange or did that experience with Diane McIver last on that Friday afternoon at 2 p.m.? How long were you in her office?
I would say a minute or two.
Okay. And then a couple of hours later, is that the last time you saw her as she walked past your office?
At about 4-ish that afternoon, yes.
Okay. As far as you understood, headed to the ranch?
Yes.
With her husband?
Yes.
And Danny Joe?
Yes.
Now, did you see the defendant and Danny Joe at the office?
Yes.
Where were they?
Where my office is seated is right in the front, so anyone coming in the front door or coming up the hallways, there's an open area right there, so everyone sees whomever is going in that direction.
Testimony there from Elaine Williams, who was a legal assistant at the company where the victim was the CEO. Gary Gerstenfeld is an attorney. He remains on the line with us. Now, Gary, a lot of dancing around the evidence rules there. The defense wanting to make it very clear that this witness could testify about what she saw or heard, but not to give an opinion. And then the witness said she was distraught. Well, right. I'm surprised we didn't get an immediate objection to that language, because that sounds more like an opinion. It's one thing to say she was moving quickly, she was furtive, she was breathing heavily, she was scampering around, she appeared panicked, and then you start to get into more and more opinion. To say she was distraught seems to be what the defense and the judge specifically said wasn't supposed to happen there.
Well, that's the problem, where pretrial motions are trying to keep out conclusions, and then the witness gives what is a conclusion. But it was a one-word answer, distraught. So had she elaborated or started to elaborate, I'm sure that the defense would have objected. The problem is, if you object, then you're highlighting the one word that she said to the jury. So you have to be careful about objecting about words that are once said. It's sort of once the cat's out of the bag, you're kind of stuck with it. And yeah, distraught is a conclusion, but there wasn't more to it. You could almost say that it's a description of someone. Said, if I say someone's distraught, you look at you can kind of imagine what that looks like, but it was a one-word answer, so she didn't elaborate on it. So it would have been inappropriate, I think, for the defense at that point to jump up, because again, you'd be highlighting the situation and potentially make it a bigger deal than it is. And for what is it? I mean, so what? She's upset. She may be upset a lot of the times. Who knows? She's living with a guy. They're going someplace. She could be upset about anything. That in of itself doesn't create a motive. They're scratching and looking and sniffing for motive, and now they're asking people that saw them in passing for what, 1 or 2 minutes, and that establishes a motive for a murder?
Well, you raise a good question, but it sort of brings us back to another couple of points here that are worth pointing out. Now, the state of Georgia, not terribly long ago, changed all of its evidence rules and basically adopted the federal rules of evidence, which are the model that many states use and that are increasingly being used by states. That changed the way practice was done in Georgia, but let's hold that thought. It looks like court's ready to resume after a break. We've got a new witness taking the stand, so let's go back to the Tex McIver case.
For the purposes of the court's record, please state your name and spelling.
My name is Tanner McKinney. You need to spell it?
Please.
TANNERMCKINNEY.
Good afternoon.
Hi.
How you doing?
Good.
Good. Hold on one second. I'm sorry. Let me get this out of the way. Okay. Could you introduce yourself to the jurors by telling them your name and how old you are?
My name is Tanner McKinney. I'm 29 years old. That's pretty much it.
Okay. And are you currently employed?
Yes, I am.
And what kind of work do you do?
I work at a pet cemetery as a memorial counselor.
Okay. Interesting work, I bet.
It is. It's different.
Okay. And have you always done that kind of work?
No.
What kind of work did you do previously?
I was a carpet cleaner.
A carpet cleaner?
Yeah.
How long did you have that job?
5 years.
Okay. And can you tell the jurors, currently, you don't have to give us an address, but what city do you live in?
Athens, Georgia.
Okay. And can you tell the jurors, do you live there alone or with someone else?
I live with my girlfriend Samantha there.
Your girlfriend's name is Samantha?
Yes.
What's her last name?
Watson.
Okay. And how long have you all been in a relationship?
Since 21, so about 9 years off and on.
Okay. Did you guys drive down together?
Yes, sir.
Well, I really appreciate you making the trip. Now, I want to talk to you about a real specific weekend, okay? Yes?
Yes, sir.
You just have to speak because she's writing down everything you say.
Yes, sir.
And I want to ask you, do you know the defendant in this case is Claude Tex McIver?
Yes, sir.
Okay. And can you tell the jurors how was it that you came to know Mr. McIver?
Mr. McIver offered my girlfriend free board for her horse in exchange for us for exercising their animals, their horses. That's how I know him, Mr. Samantha.
Okay. Free board for your horse
Yes.
in exchange for you and Samantha.
Exercising the other horses there while we were with our animal.
Okay. And so, how many other horses were there? We're talking about the ranch in Putnam County?
Mm-hmm.
Yes?
Yes, sir.
And how many other horses are there that you all would exercise?
Not quite sure, but about 7
Okay.
to 10.
Okay. And so, can you tell the jurors if the date of this incident, just so I'm trying to give you a frame of reference, if the date of this incident is September the 25th, 2016, and that would have been a Sunday, how many years prior to that did you and Samantha actually come and exercise the horses there at the Putnam County Ranch?
Probably about 3-4 years, something like that.
Okay.
I'm not 100%.
Okay, that's all right. And can you tell the jurors how often would you go to exercise the horses?
We would try to go every week, but of course things would happen, so a more realistic estimate would be more like 2 to 3 times a month.
Okay. For a couple of years?
Yes, sir.
Can you tell the jurors during that time period, did Samantha and yourself, you lived in Athens the whole time?
Yes.
Okay. And during some of that time, was Samantha actually in school?
She was, yeah, at UGA.
At UGA. Now, how would you describe your relationship with Mr. McIver?
It was good. It was a professional one. You know, we took care of the horses, and it was a decent relationship.
Okay. And in exchange for allowing you to board your horse there, were you paid any monies or anything to do the things that you all did with the other horses?
No.
Okay. And were you the person who actually would exercise the horses yourself, or was that Samantha?
We would both. Now, Samantha's probably more informed about training and stuff like that, but I was just as capable.
Okay. You've been around horses a lot?
Since I met Sam, since I was 20, so I'm 21.
And can you tell the jurors, during that time, those couple of years, did you also come to know Diane McIver?
Yes, I did.
Okay. And how would you describe your relationship with Diane McIver?
I always saw her with Tex, and it was pretty much the same. A good relationship.
Okay. And can you tell the jurors, when you would see them together interacting, how would you describe the way they interacted with each other?
Good. I never really saw them get in an argument or anything like that. Most Sundays was a great day. We'd go out there and we'd ride horses and get to talk to them and kind of catch up a little bit, and nothing to really break that pattern.
Okay. And other than coming to the ranch to exercise the horses, did you and Samantha have the occasion to come to the ranch for other events?
Yeah. Once a year we would help out with Austin's birthday. Mm-hmm. It was kind of like a little event where they had people over, and we'd offer horseback rides and fishing and stuff like that.
Okay. And would you get the opportunity to watch the defendant and Diane McIver interact during those social events?
Yeah.
Okay.
Yes.
Can you tell the jury, during those events, was there any drinking?
Yeah. Yes.
Okay. And would you see both Mr. and Mrs. McIver drinking?
Yeah, sometimes.
Okay. And drinking what, you believe?
They liked wine. I think Tex might have been more of a beer guy, but I don't really remember specifically.
Okay. And how would you describe those interactions during those social events?
They were pretty good. I mean, there would always be a lot of people there, and they were very social people, so they'd be making their rounds. But one of the last events that we did with Diane, they were dancing around, having a great time. They were fun people.
And you don't know why Mr. McIver asked if you could take Danny Joe back to Atlanta?
I don't.
You don't know if he and Mrs. McIver wanted to spend the night at the ranch?
I'm still objecting.
He's answered he doesn't know, so we don't need to ask more questions about that.
Okay. All right.
Sustained.
Thank you, Mr. McKinney.
Any redirect?
Just two. One. Did you tell Samantha what Mr. McIver asked you to do, that is to take Danny Joe home? Did you tell that to Samantha?
I did.
Okay. And two, did you continue to board Sam's horse out there at the McIver Ranch after the death of Diane McIver?
Yes, we did.
And when did you cease to board your horse there at the McIver Ranch?
That's hard to tell. Now, Sam had an arrangement that she made with one of her friends, and I actually went out there to get the horse the day of. But it's been probably about 2 months that horse has been on the property. Now, as far as her arranging that with her friend and stuff, I have no idea.
Okay, thank you. I'm sorry, Judge, that was 3.
We'll get it right at some point. Any questions from the jurors for Mr. McKinney? That's good. Thank you.
We are waiting for members of the jury to decide whether they want to ask questions of this witness. This judge allows that, and it's a lengthy process because the questions have to be written down, they have to be vetted, they can be objected to. And while that rolls out, Gary Gerstenfeld is still on the line with us. Gary, your thoughts about this witness? He testified that he was asked to help take Danny Joe, the friend, home on this particular day, the day that the shooting ultimately happened. He testified that there was a shooting range on the McIver ranch, not necessarily out of place for a rural ranch, but he generally said the McIvers had a good relationship. What's your overall impression of this witness?
Yeah, I'm not sure it was much of a prosecution witness, but a heck of a good defense witness. It seemed like they had a good marriage. They drank socially.
Gary, I guess we've got jury questions coming in, so we've got to go back.
Distinctly, but I just remember being a little bit revolver.
Okay. Any follow-up based on that, Mr. Rucker? Well, I mean, I have one. Do you recall a make? Is it a Remington or just an older gun?
I can't.
Okay.
Could you provide Tanner a little bit more detail about how the gun looked? Color, size, anything like that?
It was like a revolver, like a 6-shooter. Is basically the way I would describe it. It was darker, colored. It was nondescript. There was nothing that would stand out of it. There was no like labels. I don't really remember it being something that if you stuck it on a table or anything like that, you would point out at it.
Okay. Okay.
So.
Do you remember that about the gun? You said something about something that pulled back. Was that the hammer?
Yeah. Okay. I think I might have said it was the action, or I meant the hammer.
Okay. All right. Thank you.
Ms. Carter.
Yes, thank you, Your Honor. At the time that Mr. McIver showed you the gun, do you know, was there ammunition in it?
No, I don't.
You don't know if there was?
No, I don't.
Okay. So he didn't demonstrate actually firing the gun?
Yes, ma'am. He did not demonstrate that to me.
Okay. All right. Thank you.
So, folks, we are waiting for members of the jury to ask questions in the Tex McIver case. It looks like things just might not go anywhere with jury questions. The witness got off the stand. This is a witness who boards a horse and takes care of horses at the McIver ranch. So we've heard this testimony that not only did she have some interaction with the McIvers and the friend, Danny Joe, the day that this shooting happened, but also her partner also had some discussions that were similar. There were discussions about Tex McIver showing a gun. There were discussions about Tex McIver asking the day of the shooting for the witness we just heard from to take Danny Joe home. That is an interesting back and forth because the state is surely going to use this to try to say, okay, Tex McIver was planning something. He wanted Danny Joe out of there. And it seems like the state is insinuating but not asking the ultimate question, okay, there's guns on the property. There's a sort of a makeshift shooting range on the property. The defendant wants Danny Joe out of the way this particular day, but the person that Tex McIver asked to take Danny Joe home that day, those people left apparently before they were able to take her home. Therefore, Danny Joe is still hanging around. We're going to have to wait and see exactly how the state tries to connect the dots with this. It looks like they might be calling another witness based on the body language, although I can't hear what's going on specifically in court. We're waiting to see. Gary Gerstenfeld is still on the line. Gary, this seems like the classic sort of questioning where the state asks a lot of questions but doesn't tie together the ultimate point because the point would be argument. Nobody knows for sure. Let's hold that thought again, though. We've got another witness who looks like he's about ready to take the stand.
Hey, Mr. Moore, if you wouldn't mind standing back up for a second. Yes, sir. Thanks.
Raise your right hand. Do you swear and affirm that the testimony you should give the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes, sir. Please have a seat. Get as close to the mic as you can. For the records of the court, please state your name and spelling.
Jonathan Moore, JONATHANMOORE.
Hey, Mr. Moore, before we get started, were you in court earlier today?
Yes, sir.
How long were you in court?
I got here like 3 o'clock.
You've been sitting in court for a while?
Yes, sir.
Okay, so you guys aren't doing a good job of what you're supposed to do. Do you want to, I don't know what Mr. Moore is here to talk about. Does the defense want to voir dire Mr. Moore outside the presence of the jury? Because I'm happy to give you that opportunity.
I don't think that's necessary, Judge, but I expect his testimony.
Okay. Let's not have this happen again, State. They're your witnesses, not the defense. Okay. Keep going, Mr. Abate. You didn't do anything wrong, by the way. You're clear. They should have kept you outside while this stuff was happening here in court.
Yes, sir.
You can blend it all over.
Gotcha.
Could you introduce yourself to the jury?
My name is Jonathan Moore.
And Mr. Moore, are you in school?
Yes, sir.
Where are you in school at?
Georgia State.
And what are you studying at Georgia State?
Computer Information Systems.
Okay. Are you working currently?
Yes, sir.
Where are you working?
Longhorn.
Okay. And which location?
Right now, I work at the one in Cumberland by the mall.
Okay. Before working at the Cumberland location, did you work at any other Longhorn locations?
Yes, sir. I worked at the one in Conyers.
Okay. And how long did you work at the Longhorns in Conyers?
For a little over a year.
A little over a year. Okay. And how long have you been at the one in Cumberland?
Since August of 2017.
Your Honor, I'm going to attend what's been marked as State Exhibit 214, 215, and 216. They've been previously shown to defense, and I believe there's no objection.
Correct, there's no objection.
214 through 16. All right, those are admitted.
Thank you, Judge.
Sure.
Mr. Moore, I'm going to show you State's Exhibit 214. What are we looking at here?
The front of the Conyers restaurant.
Bringing back good memories?
I guess you could say that.
Okay.
He did say that.
I was waiting for my leading objection. Did you work at that Conyers Longhorns back in September, or on September 25th of 2016?
Yes, sir.
Okay. Were you working that evening?
Yes, sir.
Okay. What what was your schedule like that Sunday?
Well, when I was back then, I'm not sure for that specific day, but I always work at nighttime, so it probably was like 4 to close or 5 to close.
And that was that always when you worked at that location at the same time?
Yes, sir.
Okay. Is there anything about that night that sticks out in your mind?
Not really.
Any tables that you served that evening that stuck out in your mind?
Now, yes, but if it was never brought to my attention, I probably would never thought about it again.
Okay. So now, what stuck out in your mind?
Well, I remember the little details. Probably I remember the bill most because I always remember the Conyers location is kind of rare for tables to buy a whole bottle of wine. Mm-hmm. Normally they'll get a glass or, extra little pour, but it's not the full bottle. I remember that table ordered a full bottle.
Okay. And do you remember anybody from that table?
Yes, sir.
Okay, what do you remember about them?
I remember it was an older couple. Well, it was 3 people at first, and then one person joined us later.
Okay.
They ordered his food, and had his stuff waiting until for him to come in. And then once that was done, he kind of paid enough.
Okay. And the 3 people who were there before the gentleman, do you remember if they were all males? I know you said it was a couple, all males, all females.
It was 2 women and a male, if I'm not mistaken.
Okay. And anything about the 2 females and the male's appearance that stuck out in your mind that you remember?
No, not really.
Okay. You said you remember the bill or what? I'm going to show you what's been marked State's Exhibit 215. Can you explain to the jury, and I'll zoom in for you, what they're looking at?
Well, essentially, it's an order for 4 people. You have 2 fillets, a 7 pepper salad and a plain grilled chicken. You had water. One person had an unsweet tea. Somebody had a soup.
So I'm gonna stop you. I should ask a clearer question. What is State's Exhibit 215?
Oh, this is their receipt.
Okay. Now, at the top of 215, do you see the word open time?
Yes, sir.
Okay. And what does open time mean?
It's the time that the check was opened. So whenever I put in like the first water, or maybe if they had an appetizer, or whatever the case may be.
So it is is that about the time that someone would have sat down?
Probably like a couple minutes after, but yeah, roughly.
And then next to open time, you see where it says close time?
Mm-hmm.
What does that mean?
The time that they closed out while the food was paid for, or the order was paid for.
Okay. Does that mean when like the credit card swipe and they give you some cash?
Well, essentially, but you can write it down on the receipt.
Okay. And then next to open time, can you tell the jury what time that is?
Next to open time?
Yes.
That says 8:19.
Okay. And then next to close time,
9:02.
when the bill's paid.
9:02.
9:02. Okay. Now, the couple that we're talking about, or the 3 people, and then the gentleman, do you remember where they were sitting in the restaurant?
I remember what table.
And have you had an opportunity to come to the DA's office and kind of talk about that?
Yeah.
And did you use your artistic ability and draw a little sketch?
Yes, sir.
Okay. I'm going to show you what's been marked as State's Exhibit 216. I'll zoom out for you. Explain to the jury what you were they looking at.
Well, essentially, this is the back of the
So
restaurant.
if you do me a favor, there's a pointer sitting right next to you. You can stand up and you can point at the TV. Just that way the jury can figure out what you're talking about.
Just raise my voice since I'm not in front of the thing.
Yes, I don't think you're going to have a problem speaking loud.
This is essentially the back of the restaurant. This is a party table that sits like 10.
That's the sun in the middle. That party table.
Well, essentially, it's a large round table with 8 seats around it. And there's 104 and 94 are 2 booths in the corner, and 92 is a half booth, half table, and 102 is a booth.
Okay. I want to point out the judge is the one who's commenting on your artistic ability, not the state. Now, where was the 2 females and the male sitting before the other gentleman joined them?
If I'm not mistaken, the person that joined sat at seat 1, so that left everybody else at 2, 3, and 4.
So they were at table 104?
Yes, sir.
Okay. And was that the section you were serving that night?
Yes, sir.
Okay, you can sit down. And did you, after the bill was closed, did you pay attention to how long the 4 people sat at the table?
No, not necessarily.
Okay. And at that location, if you know, and if you don't, I don't know is a perfectly fine answer, but was there a video surveillance system or cameras within the restaurant?
Not to my knowledge.
Now, you were talking about the bottle of wine.
Yes, sir.
I'm going to zoom in. And when you point on the receipt where that is, do you see it?
Yes, the Trinity bottle of Trinity Oaks Pinot Noir. It's the bottom.
Okay. And explain to the jury again why that sticks out in your mind.
Because most tables don't come in and order a whole bottle. They'll order individually get different glasses or whatnot. But it was rare for that location, at least, for people to come in and order a full bottle.
Okay. Is it less rare at the Cumberland location now?
Yeah.
Okay. Did you get a good tip that night?
Yeah.
No further questions.
Yes, sir.
Clark Palmer,
Yes.
any questions for Mr. Moore?
Mr. Moore, my name is Amanda Clark Palmer. I represent Mr. McIver. Good afternoon. How are you?
Well, how you doing?
I'm doing well. I used to work at Longhorn when I was in college, so I remember Flo's Filet very well.
Yes, sir.
Do you still have to sing the birthday song?
Nah, we stopped that.
Thank goodness. Okay. It caught your attention that they ordered a bottle of wine because I saw on the bill the bottle of wine cost $25, right?
Yes, ma'am.
And generally, hopefully, the bigger your bill gets, the bigger your tip is going to get.
Yes, ma'am.
Right? So we're happy when people order bottles of wine.
Yes, ma'am.
Okay. And you said that that didn't happen so much at the Conyers location, right?
Yes, ma'am.
But do I understand that now it happens to you more often at the Cumberland location that you're at now?
Yes, ma'am.
Okay, so that's a good thing.
Yes, ma'am.
Okay. All right. Thanks very much.
No problem.
Any follow-up, Mr. Abate?
No, Your Honor.
Any questions from the jurors? Okay, they do. Sure. Mr. Moore, do you recall if the people who were sitting at table 104 took the bottle of wine with them when they left?
No, they're not allowed. We don't allow customers to leave the establishment with alcohol.
Okay. Any follow-up, Mr. Abate?
No, Your Honor.
No,
Mr. Clark Palmer?
And I'm handing the card back.
Okay. Thank you. So, Mr. Moore, you are free to go. Appreciate you being here. Good luck at school.
Okay, folks, it looks like trial has wrapped up in earnest in the Tex McIver case this Wednesday afternoon. You heard the judge say there just wasn't enough time to really get into any detail with any additional witness, but he does want the jury to start working a little bit later until about 5:30 in the evening to try to keep this trial on course. It's scheduled to be a relatively lengthy proceeding. Gary Gerstenfeld is still on the line with us here at the Law and Crime Network. Gary, we've had a lot of witnesses. This last one worked at this restaurant where apparently the defendant, the victim, and the friend were together. It sounded to me like ultimately this was just an attempt to establish a timeline, that apparently they left the ranch and then went to this restaurant before they were on the highway and the shooting happened. That seems to be the purpose of this witness.
For whatever it was worth, yeah. I mean, it didn't move the ball along in any marginal sense. But I guess they're trying to establish nobody's contesting, that this happened in the automobile or this happened on the highway. So I'm not sure exactly why that's so important.
Yeah, there was some discussion about the check being split. I mean, again, are we supposed to read something into that? Or, look, is that uncommon and how was it split? So we have a few more details here, but again, and we keep going back to this, the state really seems to be going to extreme lengths to try to paint this financial motive for murder. That's the state's allegation. And they're trying to get into the splitting of this check between at least one of the McIvers and presumably the friend. Is that evidence that people are in poor financial straits?
You make of it what you will. I mean, if there's problems financially, I don't think the paying or not paying or who pays on a restaurant bill is going to, be a determining factor. It certainly seems kind of bizarre. And the testimony we heard of Mr. Tanner McKinney didn't really take us very far. I mean, what he says is they have a nice relationship. He didn't see anything unusual. And he was unusually asked if he could give Danny Joe a ride home, but he doesn't know why that was asked, so it doesn't seem to make a whole lot of difference. And there's nothing established about what was special about September 25th. Now, September 25th, there's no urgency that seems to be established as to why that particular time or that particular day we need now to kill this person. That doesn't make sense. So, okay, so please take Danny Joe home. He says, no, I can't do it. It's not convenient. Okay. So what? How does that lead us to this, now I'll have to shoot her in the car and I have to have Danny Joe as a witness? How does that
any sense, and how does that move the ball in prosecution? How does that move that ball forward? I don't think it does.
Well, I mean, I guess it nudges it, but it only nudges it about a millimeter. So, you know, I guess it's worth what it's worth. So a couple of legal things that have been going on here. One of our other trial analysts, local criminal defense attorney, former prosecutor Julie Rendelman, commenting on Twitter right now. How is it that this witness, this last witness, the state's witness, managed to be sitting in the courtroom during this proceeding and nobody noticing that the witnesses aren't supposed to be listening to everybody else testify? You know, how is it that the state allows that to go on?
You know, I don't think he was an important witness. I'm not sure why he was called. You know, I don't think it makes a big difference one way or the other.
It ultimately doesn't, but look, I mean, if the rule is that they're not supposed to be in there, is somebody paying attention to this?
Yeah.
I guess the silence speaks volumes. And, you know, another thing, I've noticed the defense today getting a lot more tight about hearsay objections, because this was a big issue yesterday. There was a lot of hearsay coming into the proceeding. Now, I started to say this before. I want to bring this up. Georgia recently adopted the federal rules of evidence as also the state rules of evidence. That changed the playing field for trials in Georgia. One of the big changes was this. Under the old rules, if an objection wasn't lodged live in court the minute it was needed, it could still be raised on appeal, apparently. Well, under the federal rules, you've got to object contemporaneously on the record in order to make a finding on the record that that is the exact spot where the appeals court can come in and sort of peel everything back and determine whether there was something that needs to be reversed. Part of me is wondering if, even though this change happened a while ago, if the litigants are still getting used to it here. By the litigants, I mean the state, the defense, perhaps even the judge, because it changed the proceedings. And also, this may have been a drastic departure from the previous rules of evidence in Georgia. Could it be that that's what we're watching play out here?
It's possible. I mean, you get a certain way of asking questions or doing something. For example, if you notice the prosecutor, when he asks questions, he always likes to say, tell the jury, and then asks the question. He likes to do that as if, you know, that's just something he likes to do. So you get a certain style that you develop, and that with what you understand are comfortable with the rules of evidence. As those rules change, sometimes the style seems a little awkward, and so maybe that's what they're kind of wrestling with.
So I want to let everybody know what's also going on in court right now. They're still talking, that is the litigants and the judge, about exactly what's going on. They're determining just how late they want to go, whether they want to keep going. It's a lot of behind-the-scenes discussion. Apparently, as I'm being told, nothing horribly serious, so we're going to save the audience from the tedium of having to go through it. Gary, we've been talking about a lot of things with relation to this case. The state is calling just about everybody who ever talked to these people to try to lay out a timeline. Does it lay out the motive? We seem to have a lot of questions about it. That all plays into whether or not the defense can say, hey, look, the state didn't prove its case beyond that key phrase, a reasonable doubt.
I love that phrase. It's an awesome expression, beyond a reasonable doubt. And, you know, so far what we've heard, you know, is this a strong case? You know, witnesses we've just heard from, clearly, you know, the main facts of the case are not in dispute. There's no question that Tex shot and killed Diane. There's no question about that. The question is, was it a horrible accident, or was some sort of an intended thing to do? These witnesses didn't really move the ball forward in that direction. And really, the bottom line is the people who will know, well, I guess would be, you know, obviously Tex, we're certainly going to hear from him, and obviously Danny, Joe. These other people, particularly, you know, Tanner and Samantha, they're young kids. Their relationship with these people is going to be very limited. It's a semi-professional relationship, but they're not close personal friends. These are observations that are made in the course of these two kids doing, you know, their job with the horses, and that's the nexus between them and Tex and Diane.
Yeah, I think the key thing that they were trying to get out of that was that there was a request lodged the day of the shooting by Tex McIver for the kids, as you call them. They're in their very early 20s, legally adults. Just to remind you, but this request that they take the friend Danny Joe home. Well, ultimately, Danny Joe drove the McIvers home, and so what was going on with that request? We don't have the whole picture of why things changed, but it seems like the state may be trying to elicit that testimony to ultimately argue that maybe, again, this is insinuation, this is theory, Tex McIver was plotting something and he wanted Danny Joe out of the way. And look, does it hold up? I don't know, but maybe that's where they're trying to go with it. And they can't ask the question directly because nobody knows the answer. They just have to insinuate it.
Yeah, Aaron, you make an excellent point. You can't make a case based on speculation. You're not going to make a murder case based on this sort of insinuation. If that's what you're grabbing at to try to make a case, you've got an uphill battle. As compared to so many of the other murder cases that you've covered, where motive is clear and the evidence is so strong. In a case like this, the motive for the murder is very, very weak, and the time and place doesn't make sense. Again, one of the things that was established by Mr. McKinney is the fact that there's a place, there's a place on the ranch where they shoot. It seems to me that if you want to kill Diane and you're going to do a handgun to do it, it seems to me that would be the most logical place to have an accident, and certainly that would be the one to be the more difficult to try to prove than in the backseat of an automobile with Danny Joe driving. I think that in a way, although these are prosecution witnesses, I think ultimately in closing, I think that they actually maybe in establishing the unlikeliness that the setup in the car would be the place that Tex would have set up as a plan to kill his wife.
Yeah, we'll have to see how this plays out. They're talking about the trial going on to the end of March. So we're going to wrap up for the day. Gary Gerstenfeld, good to have you back here on Law and Crime. We're going to say goodbye for the day. It looks like trial is all wrapped up. They'll be back starting at 9 a.m. A reminder that we're on the air here live at the Law and Crime Network from at least 9 a.m. until at least 5 p.m. Monday through Friday. For now, have a good Wednesday evening, everybody. This is Aaron Keller. We'll see you tomorrow.